Hello everyone. So today we are going to discuss about the union and state relation. It can be appreciated through the three major forms, that is the federal, federal and the unitary. Federation, also known as the federal state, and it is a political entity characterized by union and self-governing state or region united by the central federal government. In a federation, the self-government status of component state as well as the division of the power between of them are typically constitutionally entrusted and may not be altered. So the government or constitutional structure found in a federation is known the federalism. It can be considered the opposite to the another system. So unitary state, on the other hand, in the state governed as one single unit, in which central government is supreme and the administrative division subdivision exercise only the power that their central government is choose to delegate. The great majority of the states in the world have the unitary system, and the relation union and the state in the confederation type of the government is between that. So union does not enjoy complete control over the state like in the unitary form of government, and the state does not enjoy the complete independence from union like that in the federal type of the government. In fact, a confederation is a permanent union of the union political unit for the common action in relation to other union usually created by the treaty but often later adopted a common constitution, and confederation tend to be established for dealing with the critical issue like defense, foreign affairs, or the country's currency, with the central government being required to provide support for all members. Serbia Montenegro was the confederation what that was formed by the two remaining republics, Socialist Federal Republic Yugoslavia and the Montenegro. Neighboring is Serbia, were sole legal successor for the Yugoslavia, which consequently to the reconstituted as very loose political union. First of all, one may look into the history to understand the federation. Where the British power was established in India, it was highly centralized. This is because British has the control it from the center and ensured that power remained correlated there said. The strong center was the of the British both on the empirical and the administrative necessity, and the government of India 1919 included diarchy as a dual rule for the government for the major provinces. In each such provinces control of some area government. The transferred list included the agriculture, and the provincial list it is all other than government. So the foreign affairs. So the act is provided for the federal system, so the supervising power, and therefore 1919 act become the growth for the federal system. So 1935 there was a growth for the federal system, and British India and some in all of the states. So when India was about to become the independent, the Constituent Assembly decided legacy of the government of India adopt the federal system. In the federation is a purely an administrative convenience rather than anything else. So the drafting committee decided favor of the describing India as a union, although might be federal in structure. Dr. Ambedkar explained significance of the expression union instead of the expression of the federation. He said that important the use of the word union deliberate. So the India was to be the federation. The federation was not result of the agreement state to the join the federation, and that of the federation not being result of the agreement. So no state has the right to secede from it. So the country and the people may be divided into different states, convenience, administration. The country is integral whole. Its people is single people living under the single imperium derived from the single source. And the American had to wage a civil war to establish that the state had no right to secession and that their federation was indestructible, and the drafting committee that it was better to make it clear at the outset rather than the leave it the speculation. So finally, a number of the expert has tried to define the relation between union and the state. An expert believe that India is a federation, and it would be wrong to say that the federation comes expert. The scholar have different perspectives of the federation, and JP Sudan India system is not truly federal, but Morris Jones is saying the opinion that India follow the federation with the instance of the competitive bargaining. So competitive bargaining की बात किसने की थी? That was the Morris Jones ने की थी, and MN जोशी ने बोला था believe that the India is a quasi federal. So किसने कहा था? जोशी ने कहा था it is a quasi federal. And the KC Weir, as well as known expert of the federation, came out with the a radically different view. He observed that India is a unitary state with federal principle rather than federal state with the unitary. Wherever is power of the union and the state should be same and should be draw from the same source in the federation. He found that the scholar Indian constitution clearly given the power of the union and the state. Okay, so this is all about the federation of the India. Now one no more chapter is there. The international agreement. The union can also legislate on the state list under the 253, and the governor under the 200 can reserve the bill for the president assent. There are another article 312, creation of all India service, national emergency, presidential rule, KIG, which is demonstrated title federation towards the meanwhile the Indian constitution provides for the single citizenship rather than double, and therefore where the concludes that the Indian federation is not a true federation, but the Alexandrites opine that the federalism can never be partial, it has the complete, and the Indian system is not a federal system, and they found that Indian system has most of the feature of the federalism. He asserted that a country may have some different arrangements. Federalism is ordered to suit the country administration, and one should be not be the bogged down the small nitty-gritty. Rather, therefore, it's believed that Indian system is federal. Paul Appleby had a very radical opinion, and he was the most expert. He observed that the center is more dependent to the state, and rather than the state depends on the center. He found that the number of the developed program and policy of India are the completely under the preview of the state. For instance, rural development, district administration completely under the fold of state. Therefore, states are responsible for successfully implementing these programs. And the central government, for instance, is dependent on the district administration for the sort of implementation of this policy. So, this the center is dependent for the implementation of the policy. Let us consider some of the behavioral approach was including the Morris Jones and Marcus Frendo. They analyzing the union-state relationship. W. Morris Jones observed that union-state relationship and found that Indian federalism by and large is cooperative federalism, bargaining politics. Mamata Banerjee withdrawal from the Teesta agreement and visit the Bangladesh. This is a good example of the bargaining federalism. Ashok Chanda committee was found that the planning of the India is largely decided by the planning commission. A number of the item included to the list and also planned to the planning commission. Therefore, the commission led by the Ashok Chanda believed that the Indian system operates like a unitary system. So the union and state relationships and the Marcus Frendo was observed post independence that was federal country. It can't be defined very aptly, but the Indian federalism is reflect the diverse characteristics of bargaining, cooperative, symmetrical, paramount, unitary. In toto, there is no absolute unanimity in the defining the union-state relationship, but there are a contrasting opinion and one perspective differ from the other. All said, there is a some sort of consensus among the experts, and that was the federation is a sui generis. Characteristics of the Federation. In the Indian Federation is unique character of the asymmetry, unitary and cooperative bargaining. Asymmetry or the symmetry is a federal is found. The federation of confederation with different constituent state possesses different powers. So considerably more autonomy than the other state, although they have the constitutional status. The division of the power between center and the state. Union symmetry, asymmetry. Union state is a symmetrical federation where every state has the power and each senate is represented by the equal number of representation. Rajya Sabha is different depending on the size. So member of the goes the member represent the Rajya Sabha. This arrangement is popularly referred to symmetry. Specific symmetry. These are the specific asymmetry with regard to the administration and interstate regional disparity, law and order situation, and fixation of the number of the legislature. So the Andhra Pradesh, Sikkim, Arunachal Pradesh, Goa is the Constitution of India. Second governor of the Maharashtra, Gujarat have a special responsibility and allocation of the fund for the provision of facilitated technical education, training and employment opportunity. Third is President of India is under the state of Assam and Manipur constitute member of the elected from the tribal area. For the people in different region, Andhra Pradesh and the Legislative Assembly of Sikkim and Goa, it shall be consist of not less than equitable arrangement for ensuring the social economical advancement of the section. And now there was a spatial asymmetry. So there is a different political units in the country with varying power. Political India is a broadly classified into the state and union territory protection of the uniqueness of the particular community, and meanwhile union and not large both the population and the size. While the Jammu Kashmir joined India and it was several diverse population and regions. So majority of people in the Jammu Kashmir were Muslim and bordered the new Pakistan. So they may accede from the India and which were subsequently incorporated the famous article of 370. So Jammu Kashmir comes under the article 370 and the article which convenes the state with a unique position of the India as a union. So Jammu Kashmir has a special rights also. So constitution is a title to interpret the unique equivalent of prime minister for chief executive, a special assignment of the functional responsibility. The jurisdiction of the center were restricted to the foreign affairs, defense and communication, with the legislative state having a statutory power. This was a striking contrast to the situation of the other state where the center is assignment of the responsibility was much more extensive and where the center is a statutory power. So the under the 371 ABCDH, the state Nagaland, Assam and the Manipur, Sikkim, Arunachal Pradesh enjoy the special provision, and so this northeastern state was Assam and much smaller size of population of the Bihar, UP and MP, and they have been given the statehood become a uniqueness in the culture, and each state carries the equal weightage to the mastering the 50% of the states required to ratify the amendments. Furthermore, the Article 371, which was record the special power of the Northeast, the provision was introduced so the amendment typically at the time of the conversion or after it is India had safeguard the provided these states. So special provision included in respect to the customary law, religion and the social practice and migration non-resident to the state. The state legislation are typically given final control over the change in this provision. Indian Federation manifests a unitary character such as the war, economic depression, technological development. In India's after independence followed a foreign policy of the peace and harmonious existence with the neighboring country. In fact, the country under the leadership of Nehru followed a very benevolent approach, and now there was a China 1962. This was a serious blow. The Nehru foreign policy with the learned the country revamped the military capacity and enhance the role and the strength of the union compared to that of state. The countries across the world, including the India, face the economical depression, and it is responsibility of the center avoid the recession, depression, and a stable growing economy. And this was financial role of the center. So, as the result of the center enjoy the power, providing the unitary character. So, knowledge of the critical component of the successful implementation of the progress, and that was the most important institution for the center of the knowledge. Best of the sources, including the technological expert, and this was the sources union make the state dependent on the union and the technological matters. So now, what we want to discuss about the state, what we want to exactly discuss about the state. First is the emergence of the coalition government, and since the party was dominant, so the decisions of the state were taken. This centralized system was fractioned the federal character and imposed the unitary nature. The country has to advance with the rapid and inclusive growth, and the country has to with the marginal and weaker section of the society to ensure inclusive growth. And now, as a result, the centralizing process such as the planning commission is a very much required. This is the provide the unitary characters, union and the state relation. Under the 280, the finance commission decides the distribution of the funds, and article 275, the union enjoy the discretionary power of the state. Ultimately, the result is greater power with the union and providing the unitary power with the relationship. Legislative cooperation. Under the Article 252, the Indian Constitution has a two more as the center to legislate there himself, and the Parliament can legislate for the two or more state by the consent adoption of the legislation. So this is the legislation cooperation between the union and the state. Another example was Public Service Commission, All India Services Classification, and UPSC also play a greater role. State Public Service Commission. Institutional cooperation. There is a numerous instance where the union cooperate with the state, and the Planning Commission of India has the cooperate with the state. So, District Planning Commission and the Municipal Planning Committee to formulate implement the plans, and the union and the state such as the National Development Council and UGC Election Commission, Finance Commission, and full faith of the credit, the Indian Interstate Disputes, Zonal Council, and Chief Minister, Chief Secretariat Conference. Development cooperation, the union and the state is cooperate to having a development, and say the union and the state cooperate on the agricultural matter, state tractor organization, and the Damodar Valley union and the state cooperate in the tackling the Naxalism, which is the issue for the. Now there was an integrated committee initiated by the center to assist the Naxal area. So that is kind of the thing is happening in the state government. Next is the competitive bargaining and federalism has become the pronouns in the recent and the NDA government. Like when the Atalji was dealing with the government, Shrimal Mati Jayalalitha exploited the coalition. Similarly, the Badal kept and coalition. Mr. Chandrababu Naidu also played a card during the NDA government, and Mamta Banerjee passed the ultimatum saying that want UPA coalition. So it is not given cabinet post of railway minister. Srimati Mamata Banerjee passed in the ultimatum saying that she won't join the UPA coalition if she was not given the cabinet post of railway. In total, the bargaining politics gaining strength with the emergence of the coalition government. Nevertheless, there is some optimistic tribes who believe that collaborative polity is emerging. So the administrative relation between the union and the state has been well defined, and Indian constitution avoiding the clashes between union and the state, and the government of India has provided the basis for the administrative relationship. First, Article 256, executive power of the every state is exercised in such a way that ensure the compliance of the law of parliament. Further, union executive empowered to give such directions And the idea of the union giving the direction to the state is foreign for most federation. It is looked upon the suspicious for the district, but in the Australia too the position is more or less same. Next, under 357, the state cannot impede, prejudice the executive power of this union. If the union agency find it is difficult function with the state, the union executive empire to issue the appropriate direction for the state, and the union power giving the direction to the regard the including the specific matter, the constitution, maintenance of the communication, and the protection of the railway. Article 260. The Government of India may undertake the executive and the legislation and judicial function and foreign country on the basis the agreement with the Government of India. So this provision of the such agreements are governed by the law relating to the exercise of the foreign jurisdiction. It was the Government of India undertake the executive legislative functions in the foreign territory, and now this will within the scope, not within the scope of dealing with the normal administration between union and the state. The another provision of the facilitate the smoothen transaction of the administrative business, and that was according to this full faith and the credit shall be given to the public act and the record of the judicial proceeding of the union and the state. In all of this, the matter in this which these are the sect for the record will provide for their effects and determining the parliamentary enactment provision of this is execution of the final judgment. Article 262 Parliament may by law provide for the adjudication of the complaints with the aspect of the use, and that was the distribution of this power. The Parliament will also provide neither the state court nor the other court which shall exercise the jurisdiction, but the importance of the provision is equivalent to the context of the many state multipurpose river valley projects. Article 263 of Constitution empowers the President to appoint and the interstate council necessary so to inquire into the advise upon the disputes arisen between the state, investigate, discuss the matters, and the to make the recommendation upon these subjects in the recommendation of the better coordination. So the president empowered not only establishing such as the council but also determining the procedures accordance with the provision of interstate council established in the 19 and 19 under article 365 effect of the failure to comply with given effect. So there was any state when failed to comply with or give effect to direction in the exercise of the power of the union under any of the provision of it shall be lawful for the president to hold that has arisen which is governed of the state cannot be carried accordance with the provision of the constitution. 365 President can improve president rule. Government reports of president it is opinion that the state machinery has failed to run all India services that was council of the state can be passed the supported by not less than two-thirds of the members voting and the present. But all India service is the common to union and the state. So central government may also direct the state government to construct means of the communication, national and military importance, and the central government and the state as a project to the railway. The President of India is appointing the state governor on the advice of this Council of Ministry. He has the power to remove and that was the submit the reports to the center about the condition of the state. If the parliament make look for the declaring high waterways to the national highways, so then the union government may undertake. The Indian Federal Administration, Trade and Commerce and free throughout the country. So Parliament has the power to restrict such intercourse of the public for like trade को भी restrict कर सकता है Parliament and state legislation too. Article 350A facilitates the instruction in the mother tongue, and it shall be the endeavour of the every state to every local authority within the state to provide adequate facilitation for the instruction of the mother tongue, education for the children belonging to the linguistic minority. Under the 2A of the Union list, the central government has the power to deploy any armed force of the union and the force for the control of the union. So that was the state civil power. Power under this enter upon the only in the serious emergency and civil authority. Now, union state legislative relationship. The relation between the union and the state is the very bedrock for the Indian federal system. India's federal state, which is the national government and the government of each constitution, although the structure of India is a federal, it is generally way yet the certain aspect of the unique for the federation. So the constitution based on the principle of the federation with a strong indestructible union has a scheme for the distribution of legislation power, blend of the imperative for the diversity with the drive of the common national endeavor. The constitution adopt the threefold distribution of the legislation power, placing now there was a union list, state list, concurrent list. 245 and 246 demark that legislation domain and subject to the controlling the principle of the supremacy of the union, which is basis for the entire system, and the union is the contain the subject of national relevance such as the defense, atomic energy, foreign affairs, war, peace, citizenship, railway, income tax, and the excise, on which of the parliament has the exclusive authority formulating the law. The state list is the include the subjective importance of the state such as the public order, police, local government, public health, agriculture, over which the state has the exclusive authority. So the concurrent list is the containing the subject of the mutual relevance and that which is the parliament and the state can be legislate and that was the conflict of the union will be prevail. There will be criminal law and the procedure of the family law, interstate trades and the commerce and the electricity, newspaper, books, education, stamps, and however there was a multiple matters. So the under the Article 249, Rajya Sabha is recommended with the two-thirds of the majority for legislation of the state. For 252, two or more than two states is the given the agree for the legislation, and 253 under the important treaty and international agreement. 250 that was during the national emergency, the parliament has the power to the authority for the subject of the mentioned in the state list, and that was all of the power has been governed by the parliament, and that was given here. Under Article 356, during the President rule, the President of India has the Parliament to exercise the power of the state legislation. All such laws also operate within the 6 months after the proclamation of the emergency. 248 statutory power are under the control of the Union government, and the 169 Union Parliament has the power to abolish state legislature. सो पार्लियामेंट अबॉलिश करता है स्टेट लेजिस्लेचर को और रेस्टरी पावर किसके पास होती है पार्लियामेंट के पास. अंडर द 200 कॉन्स्टिट्यूशन द गवर्नर एम्पावर टू रिजर्व द बिल फॉर द स्टेट लेजिस्लेशन एंड द प्रोविजन हैज़ द कंसिडर्ड द डिग्री ऑफ द रिसेंटमेंट अमंग द गवर्नमेंट स्पेशली ड्यू टू द डिलेज इन कम्युनिकेशन and decision of the center in the state on the bill is to be reserved. The union state legislation was relation have been member of the issue such as the power union statutory power to the union. The office of the governor being influenced by the reservation of the bill by the governor for the consideration of the president. The finance relation between the important aspect and no federation can be successful unless both the union and the state have their disposal of the financial resources for discharge their respective responsibility. To achieve the objective, Indian Constitution has made elaborate provision for the distribution of the taxes as well as non-tax revenues. So it is to be the Indian Constitution make the distribution between the legislation power to levy the tax and appropriate proceed the tax. So the Article 268, the tax has been levied by the union, collected only by appropriated by the state. Article 269, the tax levied and the collected by the union, but assigned to namely duties of the respect of the properties, agriculture, land, and the railway, sea taxes, railway fare, and white. Now there was a newspaper and advertisement and future market. Okay. So under Article 217, the taxes levied and collected by the union and distributed between this both. So for example, taxes of income, agriculture, and the collected by the government, but and distributed between the union and the state. So there was a state trade or commerce related भी होते हैं matters. Under Article 272, the tax which is levied and collected by the union and may be distributed between union and the state. So the duties of the exercise under such duties exercise on the mention and the toilet preparation shall be levied, collected by the government of India, shall be distributed. Article 271, surcharge on the certain duties and the taxes of the purpose of the union notwithstanding, but Article 269 and 217, Parliament may at any time increase or duties on taxes referred this article by the surcharge of the purpose of the union and whole of the proceeds so form of the consolidated fund of India. The state government has the many 19 item, all of the item are governed into one category, so the state levy taxes collect appropriate themselves. However, the account collected is now constitution provides the discretionary grants 275 grant in it to made in the each year for the union to such state for the parliament determined to the needs assistance particularly promotion of the welfare of tribal. 280, the finance commission has a recommendation for the president certain measure relating to the distribution of the financial resources and now union to the state and the manner in which the share of the assigned shall be distributed between the state. Under 282, the union can make the public purpose grants to the state for the complying with the directives issued for the union and the state. Under 292, the executive power of the union extend to the borrowing upon the security of the consolidated fund of India within the limit, if any of this time are time for the fixed for the parliament. So executive power of the union extend to the borrowing from the borrowing किस में है आर्टिकल 292 में है and the 293 provide the borrowing of the state as the exclusive power for this state extended for the borrowing within the territory of the India and that was consolidated fund of the state and the state may with the consent of the government of India that was loans from outside of the territory of the India. In case of the financial emergency of the 260, union shall be the corporate to give the direction to the state so the to observe the canon of the financial propriety and the other safeguard to be specified to reduce the salary allowances and the old pensions of the affairs of the state and the high court to reserve for a consideration of the president as a money bill or financial bill after they are passed by the legislation of the state. Okay, so that was to reserve for the consideration of president the money bill or the financial bill. So the Comptroller Auditor General of India is empowered for determining the manner maintenance of the accounts and after 73rd and 74th amendment the cake is now also audit accounts in the panchayats and the municipal corporation. If there is a tension between union and the state, so the it to put in the very plain words, there is a number of the issues of tension. One of the major issues is the coalition politics and there is a center and the state में कुछ प्रॉब्लम्स भी होती है बहुत सारी. तो यहाँ पे रिजर्वेशन ऑफ द बिल भी है, जैसे गवर्नर इसको रिजर्व कर सकता है. फाउंड रिजर्वेशन इट्स मोस्ट केसेस द लीड टू द virtual dead of the party to power the center and hostile relation with the party power in this bill most likely will not see the day of the light. So there has been a pressing demand for the state for the compulsory signing of the bill after the elapsing defined period of the time. There is also financial issue between union and the state like discretionary grants in the 275 and enjoy the discretionary grant to the state. Their allegation that the union has allotted his grants on the basis of their relation with the state. If relation between union and the state are congenial, identical, then the state has received larger fund. Distribution by the Finance Commission. The Finance Commission is the empowered to decide the distribution of the fund between the union and the India. The union, in order to bring out the equitable social economical development, set up the industrial backward region. However, there was a allegation that the union has the biased. So, period 1991, that is before liberalization, the union has used the licensing policy tool for the differentiation. Even today, the union has adopted the environmental clearances and other mode for the permission of the tool for the state. Recent trend through this relation between union and the state has been so many occasions. The recent development have provided a fillip in the bettering the relation between them. On this, there was a impacted the union-state relation and emergence of the coalition politics. Initially, the coalition politics has hurt the relation between union and state, but the maturing the coalition, there was a thing brighten up, and the regional political party also sharing power of the union because of the coalition government. The interest of this region is to have the represented. Now, the today the civil society has become very vibrant, and the civil society organization have started the questioning the decision of the union government. So, therefore, the government is forced to take decisions and every action of the union under the public glare of the scrutiny. Beside the early the state, they were developed by the grants provided for the union, but today the LPG state is economically sound. They are all now developed the union by the fund, and the new industrial policy have opened up. In the legal front, there was a number of the developed such as the Sarkaria Commission, Bomai case, and the Punchi Commission. Sarkaria Commission that was came in 1983, and it was a central government. This commission charter was examined the relationship between power between the central government and the country, suggested change within the framework of the India. So the commission was so name as was the headed by the Justice Rajinder Singh Sarkaria, judge of the Supreme Court, and the other two member of the committee was Shivaraman, Dr. S.R. Sen, and the commission submitted a report in 1983, and the report was contained 247 recommendations of the 19th chapter. Central government has implemented the 179 recommendation of Sarkaria Commission, and the commission did not call for the structural change but the continue to existing arrangement of the that was. Now the commission expressed the need for streamline of the provision of the state relation. It suggested that the center should relax its financial hold over the state and give them more autonomy, and this would make the regional powers more special. Role of the governor 356. The commission recommend the article 356 should be used very sparsely, extreme cases as a measure of the last resort, and when the alternative failed to the now 258, that was the administrative relation of the Sarkaria met the following obstruction. Federation is the more is function of the arrangement for the cooperation of the action, that is the institution concept. And the 258 power of the union to confer the power and provide for the tool for the liberal use of the which is cooperative federalism, realizing working of the system. A more generous use of this has been made for the progressive decentralization, and therefore the commission has recommended that should be delegated some of the union executive function in the concurrence with the state, which help the furthering the spirit of cooperative federalism. The commission recommended that the residuary power of the legislation is regard to the matter should be remain with the competence of parliament, while the residuary power has the taxation should be placed in the concurrent list. On the concurrent list, the commission recommendation that center should have the control over the subject of the concurrent list and the consult to the state government enacting the law. The Sarkaria Commission is part of the 17 interstate river water, and one of the application of the section 3 of the interstate river water dispute relation. It should be the mandatory on the union government to cooperate with the tribunal with the period of not exceeding the 1 year. Interstate river water dispute may be suitably for the purpose. Interstate Water Dispute Tribunal, and there should be a data bank for information system of national level. Interstate Water Dispute Act, states shall be inquired, give necessary data for the purpose of the tribunal may be vested. Power interstate water dispute should be amended, ensuring the tribunal become effective within the 5 years, and if the however for some reason the tribunal feels the 5 year period of the extended union government may be referred to the tribunal. Interstate water dispute 1956 should be amended by the tribunal award, and that will be the order to decree for the Supreme Court to make the tribunal for this is really binding. Award is really binding. Now, as a Bomai case, that was the 1994. It was a landmark judgment for the Supreme Court of India and discussed the length of the 356 of the Constitution, and the case had been huge impact on the center-state relationship. The misuse of the 356, popularly known as the presidential rule, to impose the control of the authority. So the Bombay case of the Union of the India came before the bench, nine judges bench of the Kuldeep Singh and the Savan and the Katha Ramaswamy. And now there was a Karnataka Janata Party which had the majority of the 83 seats in the state legislation, merged with the Lok Dal to the called the Janata Dal, and the ministry was expanded with the addition of the 13 member. So this was the 19 legislation who has the rebelled sent to the later government complaining the obtain the letter and by the misinterpretation affirmed by the support by the ministry. So Bomai case was important. In case of Meghalaya, there was a president issued the proclamation under the 356, dismissed the government of the Meghalaya and the dissolving the legislation. So this pioneer for the president was the satisfied basis of the report from the governor. CM Assembly to prove confidence for the government, and but the governor did not head the appeal but sent to the another reports, and that was president to dismiss the government is also there. So this was Bomi case. Like we should use the 356 very sparingly, not continuously. Government of the state could not be carried accordance with the provision of the constitution, so the government was dismissed and the assembly was dissolved. अगर वो accordingly काम नहीं करते dismiss कर दिया जाता है. नागालैंड में president issued the proclamation on the governor report dismissed and government of Nagaland dissolved कर दी गई यहाँ की भी. एंड मध्य प्रदेश, राजस्थान, हिमाचल प्रदेश बाबरी मस्जिद का जो केस था, देर आफ्टर द हॉनेबल कोर्ट बेन द RSS and Bajrang Dal in the country. Okay, so the BJP government of the Madhya Pradesh, Himachal Pradesh and Rajasthan failed to implement these results of conditions. Now there was a total law and order for the as a result of 15 December 92, the president of the proclamation under the 356 dismissed the state government and dissolving the assembly. The petitions containing the similar questions before this Honorable Supreme Court, the argument of the Bomai case was commenced and were concluded. The proclamation under 356 is not immune from judicial review. तो इसका जुडिशियल रिव्यू भी कर सकते हैं. स्ट्राइक डाउन द प्रोक्लेमेशन. इट इज़ फाउंड दैट malified or based on the wholly of the extraneous. So when a prima facie case is made out the challenges of the proclamation, the Union of India has to produce the material basis which was taken. It cannot be refused to do so. It is seek to defend the action. The court will be into the correctness of the material, and now there was a relevant to this. In the other one, the court find the material evidence is not relevant. So the power of the granted under the 356 is not absolute. The existence of the material fact is maybe include the governor report for the necessary condition for the implementation of the article 356. The president after proclamation has the keep state legislative assembly, and as a state legislative assembly will be dissolved only after the proclamation in the both the house of the parliament. So the court held that secularism is one of the basic feature government which is the pursue non-secular policies and contrary to the constitution. So this was also important. After the Bomai case imposition, the president rule in the state has been drastically. For instance, IK Gujarat government recommendation for the president rule and BJP government headed the Kalyan Singh. This is for the confidence and the voting rights, and now there was a lots of case regarding this Bomay case. In 98, Bihar, recently the Bhutta Singh, governor of the Bihar, recommended resolution of the assembly. The Supreme Court ruled that Mr. Singh has acted harsh and federal cabinet. Therefore, the president rule was not imposed in the Bihar, and governor of the Karnataka recommended for the president rule in the Karnataka, and this was not accepted. But through Dr. Ambedkar in Article 356 has virtually become dead. ओके नाउ पुंची कमीशन की रिपोर्ट आई थी. सो 28 अप्रैल 2007 टू लुक आफ्टर टेक द लुक सेंटर स्टेट रिलेशनशिप was headed by the former Chief Justice of India K.M. Punchi. Despite the work put in the Justice Sarkaria, not much but was made in the facilitating better center-state relationship. Therefore, term of the reference of Justice Punchi Commission as a step forward for the Justice Sarkaria, and the Commission has dealt with the length of the 355 and the 356, proposing the safeguard to prevent their abuse and dismiss of the state government. The Commission submitted the reports of the seven volume that make the report, and the first deal with the revolution of center-state relationship. The second volume given into the constitution scheme for the covering the regarding the Article 19 and 355, 356, 263. Third volume was the economical financial relation, including the planning model, remove the regional imbalance. And fourth was the 73rd and 74 amendment. The fifth volume dealing with the internal security, covering issue of the terror, Naxalism, insurgency and communal violence. And the sixth was given the environmental issue, resources, particularly of the river, mineral, and while given the seventh volume. So the commission was appointment of the removal of the governor. So commission observed that the governor should be have a right to cessation and the prosecution of minister against the advice of the council of minister. However, it want to conversion of the making the chancellor of university. The nominee of the appointment of the governor should have the participated in the active politics at even lower level for the least of the couple of the year, and the dismissal of the governor should not be arbitrary. This should be the fixed tenure for the governor, as well as the removal through the impeachment by the time of assembly. And the scope of the discretionary power of governor under Article 163 should be limited, and discretionary power should be limited. A clear guideline should be laid down appointment of the CM, and a pre-poll alliance should be treated like एक तो कैसे आपको अपॉइंट करना है, एंड प्री पोल अलाइंस शुड बी ट्रीटेड एज वन ऑफ द पॉलिटिकल पार्टी. So, under this precedence followed the governor in case of house, the governor should first call group with the largest pre-poll largest number commanding 355. There should be amendment to enable the bring the specific trouble area under the rule for limited period, localizing the state emergency, that is as a district part of the district board under the governor rule instead of the whole of the state, such as the provision should be between not be the duration of the more than 3 months. The right of the give sanction for the prosecution of the ministry against the state. The national integration should be meet at least once a year. National Integration Council should not be given constitutional status. And internal security. There should be a procedure to ensure the smooth cooperation between center and the state for the National Investigation Agency. And the administration has to be in the line of the constitution which prepared by the people, country and amend the elected representative. So doctrine of pleasure has been understood. फाइनेंस कमीशन में तो काफ़ी चेंजेस आ गए हैं. 6 अभी तो 6 इसके ऑर्गन हो गए, इसमें तो 4 ही ऑर्गन होंगे. फाइनेंस कमीशन एज इंडिया आर्टिकल मतलब ये 1951 में आया था. आर्टिकल 280 के अंदर इसको रखा गया. प्रेसिडेंट इसको अपॉइंट करता है. इट वाज द फॉर्म डिफाइन द फाइनेंशियल रिलेशन बिटवीन सेंटर एंड द स्टेट, एंड फाइनेंस कमीशन एक्ट वाज द टर्म फॉर क्वालिफिकेशन, अपॉइंटमेंट, डिस्क्वालिफिकेशन, एलिजिबिलिटी, जो भी है वो सब प्रेसिडेंट ही डिसाइड करेगा। ठीक है, तो यहाँ पे एवरी 5 ईयर में एक चेयरमैन होता है और कुछ 4 मेंबर्स होते हैं। टू डिस्ट्रीब्यूट द नेट प्रॉफिट बिटवीन टैक्स बिटवीन सेंटर एंड द स्टेट, to determine the factor government granted net to the states, and to make the recommendation present as a measure the needed for the argument of the consolidated fund of India, resources of the panchayat and the municipality, and the basis of the recommendation made by the finance commission. The state has the given the net profit for the shared center taxes should be the 32%. The revenue deficit of the progressively reduced by the eliminate followed, and the fiscal deficit 3%, targeted 68% of the GDP for the combined debt, and the medium term fiscal plans बनाए गए हैं। FRBM Act should need be the amended to the mention the nature of the which is shall be। FRBM Act की भी बात की गई थी यहाँ। Now यहाँ पे both the center and the state should as the grand bargain implement the model for the GST, an initiative to reduce the member of the center sponsored scheme and predominance of the formula based plan also there. Now the governor, the article 163 of the constitution deal with the governor। governor of the state is a dual policy, मतलब एक तो ये constitutional head होता है, second agent of the representative of the center, but there has been allegation that governor should be agent of the center। the governor is usually distinguished elder statesman होता है, who can be discharged the duties, dignity, and who is the position of the exercise what Gandhi called the moral influencing, and in fact the position and role of the governor should be 67। फिर 67 में बोमई केस आया, उसके बाद में SR बोमई का जजमेंट आया। सो 50 to 67 गवर्नर डिड नॉट प्ले इम्पॉर्टेंट रोल, पावरलेस रहा चैनल थ्रू विच इज इंटरेक्शन बिटवीन आर like outside of the office of the governor। Now governor at the work KV Rao quoted the Sarojini Naidu, former governor of the Uttar Pradesh, as having said to be the herself as a bird in the golden cage, and Professor KV Rao, that was one of the casualty, and the role of the governor was restricted in the Nehru become was political party was a power in the center as well as the most of the state। there was a hardly any difference of the opinion between center and the state, even there was any difference it was settled through the political party। Dr. Pattadi Sitaramaiah observed that the governor has no public functions and making for the rightly reports president when Nehru was added directly। So the governor engaged in the taking the ministry Shri Prakash and Doctors 1967 the governor was a chief minister was light, the number of the minister of the such However, no strong action has been taken, but the G.B. Pant and former CM of the Uttar Pradesh appointed the cabinet minister without the knowledge of the former governor। 1967 में प्रोफेसर योगेंद्र यादव remarked that the general election marked the first democratic in this election the monopoly of the Congress power was broken and the Congress was voted out the many state managed by this, and now in other words the democracy began to mature। this led the development although the different political culture, the center and the state began have a different agendas, and this state government tried to anti-Congress sentiments। for this there was a threat to the Congress government and loss of power। this is built a new dimension, therefore the governor came into the great prominence। in fact the governor has the opportunity to exercise the discretionary power, and center used the governor office for the put down the policies। governor started playing a like agent of the center। this was further facilitated, there was no procedure of appointments, but earlier governor was appointed from a different states of the CM of the state was consulted, and however the charges post Nehru was no longer appointed, but however the charges was consulted, and CM was no longer consulted, may also be belongs to the same state. However, the fallen horse of the was war was appointed the governor, or former loyal bureaucrats were appointed the governor. There was no security of the tenure, and therefore it was very easy to pressurize the governor to act as the agent of the center. For instance, BK Nehru, then governor of Jammu and Kashmir, was asked to dismiss the Farooq Abdullah, and Dr. Nehru did not dismiss the Farooq government. So another way, then the governor of the Tamil Nadu refused to dismiss the DMK. What is the बोम्बई केस? ही शुड बी लाइक एमिनेंट. बोम्बई केस आया था 1983 में, और ये था चैप्टर 4. तो यहाँ पर बोला था कि गवर्नर जो है एमिनेंट पर्सन हो, ही शुड बी आउटसाइड फ्रॉम द स्टेट, ही शुड बी डिटेच फ्रॉम द लोकल पॉलिटिक्स, मतलब वो लोकल पॉलिटिक्स में का पार्ट नहीं होना चाहिए. It is desirable for the politicians of the ruling party of the Union Party and govern of the state which is being run by the some other party or the combining other party, in order to ensure the effective consultation with the state. So the consultation should be prescribed by the constitution and the amendment. The vice president of India and the speaker of the Lok Sabha may be consulted by the ministers. तो जो वाइस प्रेसिडेंट ऑफ इंडिया है और स्पीकर जो है वो भी कंसल्ट किए जाने चाहिए. ठीक है. अपॉइंटमेंट ऑफ गवर्नर. द गवर्नर शुड हैज़ द टेन्योर ऑफ द 5 year एक्सेप्ट द कंपेलिंग द चूजिंग ऑफ द चीफ मिनिस्टर, एंड द गवर्नर शुड हैज गाइडेड बाय द प्रिंसिपल. इफ देयर इज अ सिंगल पार्टी विच एंजॉय द एब्सोल्यूट मेजॉरिटी, then should be the forum. The party of the combination of the party which has been widened support of the legislative assembly should be invited, and the governor task is see a governance form and not to be tried to government which pursue the policies. सो ऐसा बोमई केस जो था ये आया था 1994 में. चेंज द वर्ल्ड डायमेंशन, एंड अकॉर्डिंग टू द बोमई वर्डिक्ट द इम्पोजिशन ऑफ प्रेसिडेंट रूल subject to judicial review on the subjective material imposition will not be questioned in any court. Look into the variety of the material evidences. Whatever present rule is proclaimed, the state legislation will not be discussed, and rather it would be the suspended, so until approval by the parliament. After the Bombay judgment imposition, there was a Gujarat and government recommendations. That was in 97. Government headed by the Kalyan Singh sought to the vote of confidence and violence. Like now, the Allahabad High Court also gave the decision against the present rule. In other words, the former president K. Narayan also rejected the Atal Bihari Vajpayee की जो recommendation थी. ठीक है. And the Supreme Court ruled that Mr. Singh had acted. अब यहाँ पे बहुत सारी चीज़ें हैं, मतलब बहुत से लोग हैं जिन्होंने जो जो किया वो लिखा है. इसके बाद है नेशनल कमीशन टू रिव्यू द वर्किंग ऑफ द कॉन्स्टिट्यूशन. दैट वाज इन 2000, और इसने सजेस्ट किया था कि पॉसिबल अमेंडमेंट्स होते रहने चाहिए कॉन्स्टिट्यूशन में. इसके बाद में जो जस्टिस थे, रिटायर्ड जस्टिस इंडिया ऑफ द एमन वेंकटाचलैया जी थे. तो इन्होंने कहा था कि कमीशन द सबमिटेड द रिपोर्ट इन 2002. द कमीशन रिकमेंडेशन स्क्रूटनी ऑफ द टेन्योर, एंड इट ऑल्सो रिकमेंडेड गवर्नर शुड बी अपॉइंटेड आफ्टर द कंसल्टेशन ऑफ द स्टेट मिनिस्टर CM, and should be eminent person some walk of the life and not those who have been a active politics. So, and the practice of this governor as the agent of the center or the worse, but at the center need to be the like Punchi commission also made the recommendation appointments of the governor. तो पुंची कमीशन ने मेड किए. From this about discourses, it is quite clear that role on the position of the governor has changed, and the governor has two important roles. पहला है कि representative of the center, responsible to the see the federal balance between the political stability. ठीक है. On the other hand, head of the state का भी होता है. So they enjoy the discretionary power. Generally speaking, there is no overlapping between the two roles. And now governor is a so-called the agent of the center, where his role is constitution head of the state is. And chief minister जो होता है is the head of the council of ministers, so head of the state, head of the government, and under the 163 Indian Constitution, the governor exercises the power and perform the function of aid and advice to the Council of Ministers, such as the headed by CM. CM is occupied a very important post and leader of the State Council of Minister. His power and functions are more or less similar to the Prime Minister. The only difference is that they exercise their power. The CM is undoubtedly enjoy the inevitable status of constitution set up the government. In fact, the CM can be described as the keystone of the cabinet and the moon among the laser stars and the sun around the ministry is all the planets. So the appointment of the removal of the CM is provided the article 164, which is CM shall be appointed by the governor and the other ministers shall be appointed by the governor on the advice of the CM. And the about the manner of the selection of the CM, the governor appoint the leader of the majority party में जो बंदा होता है उसको CM अपॉइंट किया जाता है, ठीक है. So now in case of the party common absolute, governor can use some discretionary for the appointing the CM, provided the CM could gain the majority of the confidence. After appointing the CM, the governor give the formal approval to the list of the ministry to the including the council of ministry. So the council of ministry is the function during the pleasure of the state legislation, and the council of ministry in the office long lower state legislative assembly. So the council of ministry is the collectively responsible to the function of the legislative assembly. ठीक है. इसके बाद क्या है कि मतलब जो मेजॉरिटी में होता है ना उसी को ही रखा जाता है, ये ध्यान रखना है. अभी पावर और फंक्शन ऑफ द सीएम, तो पहला पावर है कि सीएम इज़ द वर्किंग हेड ऑफ द स्टेट गवर्नमेंट एंड गवर्नर के जितने भी मैटर्स होते हैं जैसे कि मिनिस्ट्री को चेंज करना हो, पोर्टफोलियो वगैरह को रिमूव करना हो, ही प्रिस्क्राइब द मीटिंग ऑफ द काउंसिल ऑफ मिनिस्टर and he may thus advise the minister to the resignation, may advise the governor for dismiss the ministers. His communication और all decisions of the council of ministers के जितने भी decisions होते हैं, proposals होते हैं, he furnish the governor such information relating to the administration of the proposal affair of the legislation. He plays a matters of the consideration of council of minister where required to decision taken. He acts as a role for channel of the communication, and chief minister is the sole channel of communication between the ministry and the legislation. All the bill and resolution have been moved to the legislation must have the approval. When there is a much criticism, government the legislation himself hold the face so the opposition से related जितने भी matter होते हैं. He is the leader of the majority party and much. It is the duty of see the discipline maintained and appoints the whip and see the order of this whip. He may be tendered the resignation at any time of the advice to the governor to summon such person, and through the theory all the appointments are made by the governor, yet the practice the patronage vests with the CM. No posting or transfer take place without the approval of the CM. Okay. So CM is the vested the many powers. He has the real position depends upon पॉलिटिकल एक्सपीरियंस होता है, एडमिनिस्ट्रेटिव कैपेबिलिटी होती है इसके पास. सो जैसे पीएम होता है ना वैसे ही सीएम होता है स्टेट में. सो चीफ आर्किटेक्ट होता है ऑल पॉलिसी के, एंड दीज पॉलिसी आर डिटरमाइंड बाय द बेसिस ऑफ द कैबिनेट डिसीजन. So he enjoy the support of the single majority party, and CM is a leader of the cabinet and the leader of his party, leader of the legislative and leader of the people. अब चीफ सेक्रेटरी जो होता है ना एक्स ऑफिशियो सेक्रेटरी होता है काउंसिल ऑफ मिनिस्टर का. he is known as the secretary of the cabinet. He is the chief secretary hold the position of the state administration that has no comparison within this center. The post of the chief secretary is enacted within the Indian administration that IAS officer may hold the position. The chief secretary hold the same rank as the secretary of the government of India. By tradition like IAS officers ही होते हैं chief secretary, but in many cases he is not so. So the through this chief secretary is a apex administration, and his functions are defined by the rules of the businesses. Each state government frame itself. There is a amend to the time. So रोल ऑफ द हेड ऑफ द कैबिनेट सेक्रेटरी डिपार्टमेंट का ये हेड होता है. चीफ सेक्रेटरी एक्टिंग एज ए पॉलिटिकल हेड. ठीक है. चीफ मिनिस्टर तो पॉलिटिकल हेड होता है, ये एडमिनिस्ट्रेटिव हेड होता है। वर्क परटेनिंग टू द कैबिनेट मीटिंग्स, जितनी भी कैबिनेट की मीटिंग्स होती है ये अरेंज द मीटिंग्स एंड रिकॉर्डिंग्स जितनी भी होती है डिसीजंस की कैबिनेट मीटिंग्स एंड फॉरवर्ड द कॉपी टू द गवर्नर सीएम को। पार्टिसिपेशन इन द पॉलिसी को फॉर्मुलेट करना एंड द चीफ सेक्रेटरी ही एक्ट एज ए मेन सोर्स ऑफ द इंफॉर्मेशन ऑफ द एडवाइस टू सीएम। Secretary is attend all the meetings of the cabinet. He is the become the crucial because which is the long administrative experience होता है इसके पास में एंड ये बैलेंस बिठाता है पार्टी के बीच में और एडमिनिस्ट्रेशन के बीच में और इम्प्लीमेंटेशन के लिए। रोल इन द फॉलो ऑन द इम्प्लीमेंटेशन ऑफ कैबिनेट डिसीजन, जितने भी कैबिनेट डिसीजंस होते हैं उन सबको अप्रूव करना, इनको अडोप्शन करना, न्यू स्कीम्स बनाना, ठीक है। एडमिनिस्ट्रेटिव हेड ऑफ द certain departments, so he is also the head of the certain departments. एडमिनिस्ट्रेटिव पर्सनल एडमिनिस्ट्रेटिव रिफॉर्म प्लानिंग, सारे डिपार्टमेंट्स में ये हेड होता है एंड कोऑर्डिनेशन भी करता है वहाँ पर। एंड चीफ सेक्रेटरी इन्फ्लुएंस इंक्रीजिंग नाउ कंसिक्वेंटली द इनहेंसिंग इन्फ्लुएंसिंग द डिपार्टमेंट को इन्फ्लुएंस करना। रोल ऑफ द हेड ऑफ द सिविल सर्विस, द चीफ सेक्रेटरी बीइंग द हेड ऑफ द सिविल रिस्पॉन्सिबल फॉर द ओवरऑल हेल्थ ऑफ द एडमिनिस्ट्रेशन एंड मॉरल को कैसे मेंटेन करना है। बफर बिटवीन द पॉलिटिशियंस एंड द सिविल सर्वेंट, मेंटेन द हार्मोनियस रिलेशनशिप। As a principal coordinator and most of the function of the chief secretary is coordinate the activities and now there was a secretary of coordinate the activities and he is expected to resolve the conflict, mitigate the various जितने भी departments की problems होती हैं। So 3 level of coordination होता है between center and the state, interstate level या intrastate level. So the secretariat with proxying to seize power of the responsibility of the all the power of the authority state government and help the minister in their individual collective capacity formulate the policies and secretariat serve as a think tank and the brain trust भी बोलते हैं इसको एंड इसके पास सारी इंफॉर्मेशन होती है। secretariat is the main coordinating agency for the planning, finance, personal and general administration. Secretariat gives the direction to guidelines through the directorate. Secretariat lay down the rules and regulation guidelines for the advise the various public agencies and help to the governing the auditing evaluating this function. Secretariat also undertake the quasi-legislative work, help the minister for legislating, framing, regulating this work. Secretariat is also the spokesperson state government and the center and the state के अंदर जितने भी मैटर्स होते हैं उसको ये देखता है। देखो जो चीफ सेक्रेटरी वर्सेस कैबिनेट सेक्रेटरी, चीफ सेक्रेटरी कैबिनेट सेक्रेटरी इज ए सीनियर मोस्ट सिविल सर्वेंट। मीन वाले चीफ सेक्रेटरी इज द हाईएस्ट रैंक ऑफिसर होता है, वो सीनियर होता है तो इसकी रैंक बड़ी है एंड ही शी यूजुअली हैज़ अ सीनियर मोस्ट सिविल सर्वेंट स्टेट में है ना। बोथ द कैबिनेट सेक्रेटरी हैज़ अ एपेक्स हायरार्ची, बोथ हैव द एनहेंस्ड फ्रॉम द आईएएस से आते हैं। Chief Secretary is the highest ranking in the state and the Cabinet Secretary is the senior most and highest in the center. Chief Secretary is the secretary to the government of the respective state and the Cabinet Secretary is the secretary to government of India. Both officers is the memory of the information. Both faces the civil at the center state level. They are expected to lead to the Indian administrative service and they boost the morale of the service. However, Cabinet Secretary and the Chief Secretary enjoy different powers. The Cabinet Secretary is for the whole of the India while the Chief Secretary only for the state. Cabinet Secretary status the order of the President is above the Chief Staff and equivalent to the other service holding in the rank full general and equivalent to that of the Attorney General and Lieutenant Governor within the territory. His rank is higher than the rank of the Secretary to the Government of India, whereas the Chief Secretary rank is Secretary to the Government of India. So Chief Secretary की तो only Secretary to Government of India है. The Cabinet Secretary preside Chief Secretary conferences. Chief Secretary is a Secretary to the state and the Cabinet Secretary is a Secretary to the Union Cabinet and he is Secretary to the Chief Minister like the Principal Secretary of the Prime Minister Office. ठीक है, तो जो Secretary होता है the Chief Secretary is the Chief of the State Secretariat का होता है while the Cabinet Secretary is not only the Chief of the Central Secretariat but also the Prima Inter Pares. The Chief Secretary is the head of the Department of Personnel, Planning, Finance, General Administration. Other words, the department of the state government directly under the charge of the Chief Secretary, while the no department of the Central Secretary is under the charge of the Cabinet Secretary, except the Cabinet Secretary. Chief secretaries may be secretary to the number of the ministries, but chief minister of the state tend to hold the number of the portfolio. Chief secretary is the residual legatee, and while the cabinet secretary is not the residual legatee. तो कहीं पर कहीं कहीं पर कैबिनेट सेक्रेटरी के पास ज़्यादा पावर है और कहीं कहीं पर चीफ सेक्रेटरीट के पास ज़्यादा पावर है. So, the chief secretary act as the alter ego of the CM, while the president issue the 356, but the same not true in regarding the cabinet secretary. Always prime minister and the council of minister in the country वही करते हैं ये काम. Now, in the recent decade, the authority of the chief secretary in the state has declined. क्यों? क्योंकि एक तो nature of the appointments, like the chief secretary का जो appointment हुआ है किरण बेदी का हुआ था, was not appropriate commissioner of the Delhi, and instead of the Dadwal in 1974 batch was appointed as a commissioner. It is being capable concern. It was noticeable that the Kiran Bedi was of the traffic Delhi, Goa, head of the Tihar jail, and has also served as the police service. तो काफ़ी नेचर अपॉइंटमेंट में चेंजेस आए हैं. नेचर ऑफ द रिमूवल, द चीफ सेक्रेटरी इज यूजुअली मूव फ्रॉम द पोस्ट विद द गवर्नर ऑफ द स्टेट. दिस हैज़ बिकम ए नॉर्म्स. However, the instance of the chief minister has continued with the same chief secretary. Okay, and the tenure, the chief secretary according to the personal management rule is outside the tenurial system. And however, there is an instance where the post is not kept outside the tenurial system. And cases of corruption, some of the chief secretary involved in the corruption. Political associations होते हैं बहुत सारे. Appointments of the national advisor जितने भी हैं. Case of the imposition of the president rule does not in the confidence of the CM, and the national advisor are against the मतलब वो सेंटर के अगेंस्ट वर्क करते हैं. क्रिएशन ऑफ द पोस्ट सच एज द प्रिंसिपल सेक्रेटरी. तो प्रिंसिपल सेक्रेटरी अपना काम करते हैं तो चीफ सेक्रेटरी कैसे करेंगे. सो इससे नंबर ऑफ द रिकमेंडेशन हैव बीन गिवन. फर्स्ट, एम्पावरमेंट ऑफ द चीफ सेक्रेटरी. तो अपॉइंटमेंट ऑफ द चीफ सेक्रेटरी शुड बी एज ए पैनल एम्पावर टू द एमिनेंट पर्सन. इनको सिक्योरिटी ऑफ द टेन्योर देना चाहिए. एक एमिनेंट पर्सन ही हो जिसको कि चीफ सेक्रेटरी बनाया जाए, अदरवाइज नहीं बनाया जाना चाहिए. एंड स्क्रूटनी ऑफ द लेजिस्लेशन, उनके लेजिस्लेशन की स्क्रूटनी होनी चाहिए. चीफ सेक्रेटरी शुड बी केप्ट आउटसाइड द टेन्योर सिस्टम. और आउटसाइड द टेन्योर सिस्टम कहा गया है कि इसको टेन्योर सिस्टम से बाहर रखा जाए. थ्रो द क्रिएशन ऑफ प्रिंसिपल सेक्रेटरी अनबर्डन द चीफ सेक्रेटरी वर्क. तो एक प्रिंसिपल सेक्रेटरी भी हो ताकि इसका वर्क कम हो. एंड द क्रिएशन ऑफ द प्रिंसिपल सेक्रेटरी शुड नॉट बी अंडरमाइन द चीफ सेक्रेटरी. और इसकी पोजीशन को मतलब वो अंडरमाइन ना कर पाए. ऐसा नहीं है कि वो इसकी पोजीशन को मतलब अंडरमाइन. तो पहले बताया गया था कि इसको टेन्योर सिस्टम, ये देखो, सिक्योरिटी ऑफ टेन्योर मतलब चीफ सेक्रेटरी शुड एंजॉय द सिक्योरिटी ऑफ द 2 year इन स्पाइट ऑफ डेट ऑफ सुपरएन्यूएशन. तो यहाँ पे कुछ ना कुछ सिक्योरिटी ऑफ टेन्योर हो और इसको टेन्योर सिस्टम से बाहर भी रखा जाए. अब लिखा हुआ है ना कि चीफ सेक्रेटरी शुड बी केप्ट आउटसाइड द टेन्योर सिस्टम. ठीक है, तो ये पूरा हमने चीफ